Yes, Lordship, may I permitted I mention the matter appeared in the list application, my lord. Application. Upon notice? Yes, my lord.
May I permitted to mention your lordship, my lord, for inclusion in the list, my lord, for under the hearing matter, my lord.
Upon notice?
Yes, my lord. 5 matters are there, my lord. Grateful to you, lord.
This is a matter of 23, my lord. Affidavits are complete, a report has been filed. Matter could be, my lord, disposed of because we are agreeable, both the parties. What happens is, my lord, my building has been declared to be dilapidated. Government was a tenant in my building with regard to 300 odd square feet of land. Lord Justice Sinha passed an order while sitting in Lord motion that if we agree to give them or rehabilitate them the area, the state has agreed to vacate. Lord, state has given some area, we are almost agreeing to that. If it appears that to be mentioned, I'll give notice to them, but it could be disposed of.
Have you given notice?
Lord, keep it on Friday, I'll give notice and come back. Because I'll be very candid to you.
You give notice? Yes.
I tell you,
Mention tomorrow what can be.
I tell you also only one thing. I have, Lord, wrongly given notice that I'll mention it before Justice Kant. So that is why, Lord, tomorrow I'll not be available. Kindly accept it. I'll give notice to them that I have mentioned it before my Lord. It will appear on Friday. If I cannot show the notice, do not take it up the matter. Tomorrow, that's the only thing.
Okay.
I'll give notice.
Tomorrow better call.
To be mentioned on Friday, Lord, I'll give Mr. Dadikanath Mukherjee is appearing.
Tomorrow?
No. Yeah.
To be mentioned tomorrow.
Don't listen to them. Don't listen.
Okay. Oh. Okay. Notice, have you given notice? Grateful.
Your Lordship, may I be permitted to mention one matter for inclusion of the list? For inclusion of the list. In this matter, the petitioner here is an old age person and is deprived by his legitimate dues from the government. So I'm humbly praying for.
Have you given notice?
Yes, we have served.
Okay, give it.
Grateful, my lord.
Senior citizen. Pensionary benefit. Retirement benefit.
Yes, my lord. Grateful.
Yes, call the list.
Item number 1 and 2.
Lordship, my total instruction from my junior lordship, but he did not come to the call due to the lots of bar.
He has met with an accident, I am told. So, kindly takes it up tomorrow.
Tomorrow, lordship, tomorrow. Friday, lordship. Friday.
Friday দিয়ে দেবেন তো এটা হ্যাঁ ওকে
Item number 3.
3 তো not today করতে করতে যান আজকে তো
Item number 3, my lord, I am for the petitioner, my lord.
Yes.
My lord, it is regarding compassionate appointment. My lord, the father of the petitioner died long back in the year 2014, my lord. Thereafter, I made several applications. My application has not been considered for appointment.
দেখি both sides.
I am appearing for the petitioner, lordship. This matter, lordship.
You are appearing for the petitioner?
Yes, lordship. The read petition number.
Oh, so both sides is not there.
Item number 4, lordship.
Oh,
Item number 3. My lord, 3, I have
other side is not present. Today you have adopted a resolution. Number 4. Item number 3.
My lord, kindly take it tomorrow at 2.
Tomorrow. Okay. Tomorrow.
My lord, 12 o'clock. My lord, tomorrow at 12 o'clock. My lord, I am a agent person. My lord, coming from far distance. My lord, 12. Subject to your lordship permission, my lord.
Tomorrow, let it remain in the list.
Yes,
tomorrow, if you have some difficulty, please send your junior to mention. It would be adjourned. Okay.
My lord.
Yeah.
I'm grateful, my lord.
4.
Item number 4, I am
I'm to this one. Against allegation against me. The order impugned.
Yes, Lordship, I have challenged. Lordship laid by Mr.
But this is an order, my lord, passed by the West Bengal Clinical Establishments Regulatory Commission. Now, my lord, the order is dated, my lord, 15th of February 21.
Ah.
My lord, Lordship would, my lord, kindly, my lord, see the tenure of the order. Now, my lord, if you may, my lord, may I place this order, my lord, before your lordships? My lord,
Yes,
page
yes,
72
page
and Annexure
72.
37.
Page
Page
72.
72.
Yes.
Now, my lord, the order starts with, we have heard this complaint on February 14, 2020, when we asked the clinical establishment to produce the nursing staff and the concerned RMO. We also requested the concerned treating doctor to be present at the next date of hearing. Today, the matter has come up for final hearing. The complaint would reveal a young lady was under constant gynecological checkup of the concerned surgeon at antenatal period. The lady was admitted in the clinical establishment for delivery. The delivery was done by the cesarean section at about 9 a.m. in the morning. On October 28, 2019, the female child was born and the patient was shifted to bed. According to the RMO, there had been a fall of blood pressure at about 1 p.m. that could be managed. However, the patient became critical and ultimately she went in ventilation at 5 p.m. and died at 5:35 p.m. according to the hospital record. Today, the clinical establishment is present. We have heard the concerned RMO, Dr. Kaustubh Shah. The clinical establishment representative would contend during pandemic, the concerned nursing staff left the establishment and as such, they are not in a position to produce her. The treating doctor is not present. Our experts on the panel have examined the medical records and the postmortem report. The postmortem report unhesitatingly opined that the death was due to antepartum hemorrhage from caesarean section wound. The primary negligence, if any, would be from the treating doctor. Lordship would kindly, my lord, mark this line. The primary negligence, if any, would be from the treating doctor, for which the complainant has already approached the West Bengal Medical Council and that is waiting adjudication. We are of the view that the clinical establishment cannot absorb their responsibility. The representative would contend time to time they inform the concerned surgeon, but in vain. When a patient is admitted in a clinical establishment, her condition is deteriorating. It is the primary responsibility of the clinical establishment to take steps for a treatment. Fact remains the concerned treating doctor never came to attend the patient. The complainant would contend the concerned treating doctor was residing close to the clinical establishment. The nursing staff informed the concerned treating doctor. He did not come at the relevant time. He came after the unfortunate death of the patient. Now, my lord, the penalty. We impose a token penalty of rupees 2 lakhs as against the clinical establishment. We permit the complainant to approach us again for final compensation after the matter is adjudicated upon by the West Bengal Medical Council in the pending proceedings. Ms. Ranjana Shil, learned advocate appearing for the clinical establishment, would pray for reduction of the amount. Considering the backdrop, we are not inclined to reduce the amount. However, we would permit the clinical establishment to pay it in monthly installments of rupees 50,000, commencing from March 121 and thereafter on the first day of each succeeding month. The complaint would contain, baby is now 2 years old. We direct the complainant to open a bank account in the name of the female child so that the money could be transferred directly to her account that would be kept in a fixed deposit till she attains majority. Now, my lord, if your lordship, my lord, sees the complaint, what was the original complaint before the commission? My lordship would get that at page 55. Now, my lordship sees the subject.
Yes.
Subject is a grievance petition against medical negligence. Lordship would mark the word medical negligence. Of treatment of Srimati Moumita Sadhuka, wife of Sanjay Sadhuka, against Dr. Ghotok, attached to Megacity Nursing Home at Barasat. So, my lord, the primary complaint was medical negligence against the concerned treating doctor. Now, my lord, why I say this? My lord, lordship would, my lord, kindly see, my lord, if your lordship, my lord, I shall give you a copy, lordships a copy of the act. Lordship would kindly come to section 38 of the West Bengal Clinical Establishments Act.
Yes. Osmo chemical.
My lord, West Bengal Clinical Establishments Registration, Regulation and Transparency
Yes,
Act.
yes. Removal of member.
My lord, section 38.
Hmm.
Now, my lordship has seen, my lord, section 38 is power and functions of the West Bengal Clinical Establishments Regulatory Commission. My lord, lordship is perhaps seeing the rules. My lord, it is the act.
Act.
Lordship, my lord, section 38, lordship has got it, my lord. Lordship can take this book, my lord, I shall rely from that.
Oh. Oh, yes, got it.
Ah,
Got it. Yes.
Section 38, my lord, deals with powers and functions of the West Bengal Clinical Establishments Regulatory Commission. My lordship would get 38 subsection 1, my lord, the commission, my lord, the commission shall, my lord, the functions of the commission are laid down. Now, my lord, lordship would kindly come to the first proviso. Provided that any complaint of medical negligence against medical professionals will be dealt by the respective state medical councils.
Hmm.
So, my lord, the third proviso to section 38, my lord, in my humble submission, my lord, debars the West Bengal Clinical Establishment Regulatory Commission, my lord, from deciding upon any allegation of medical negligence. So, my lord, my first point before your lordships would be, my lord, if your lordship sees the complaint, I have shown your lordships, my lord, the complaint says that the primary grievance, my lord, as against the complainant, or my lord, primary grievance of the complainant was, my lord, medical negligence by Dr. Ghatak. Now, my lord, if your lordship again comes back to say, my lord, page 55, my lord, what is the complaint before the commission?
Yes.
Respected sir, I am a citizen of India by birth and permanent inhabitant. That my wife Moumita Shaduka was admitted at Mega City Nursing Home at Barasat for delivery under Dr. G. Ghotok on such and such. And on 29th October 2019, a female child was born and my wife and the newborn child were in good condition. I have talked with my wife in the nursing home. I came back from the nursing home to my home at around 1 p.m. But suddenly at 3 p.m. on 29th October 2019, a telephone message came to me intimating that my wife is required to be admitted in ICU. And I rushed to the nursing home and found my wife quite normal. But at 5 p.m. on 29th October 2019, the nursing home authority told to admit in ventilation unit. And after 1 hour, the nursing home authority reported to me that my wife has expired, and accordingly I lodged a complaint at Barasat PS, White Barasat PS case number such and such. Accordingly, I pray for justice for gross negligence of treatment of my wife against the doctor and the nursing home authority who are directly involved and caused death of my wife, which is highly appreciated. Now, my lord, after this complaint is lodged, my lord, the nursing home authorities are invited by the commission, my lord, to furnish their reply. Now, my lord, the nursing home authorities, lordship would get the reply of the nursing home authorities along with all the bedded tickets of the patient. My lord, I have annexed it, and the conclusive reply, lordship would get it at annexure, my lord, P5, page 67.
Yeah. 57, yes.
67. Lordship is getting page 67.
Yes.
My lord, this is our written objection oblique reply filed on behalf of the clinical establishment against grievance petition of medical negligence of treatment of Srimati Moumita Shaduka, wife of Sri Sanjay Shaduka, son of Sri Shamul Shaduka of village Ishuboti, Dottopukur, Tetultola, Dottopukur. In reply to the grievance petition filed by the complainant dated 28th November 2019, we would draw the kind attention to the following facts starting from the eligibility being registered as well as government approved nursing home. Firstly, the eligibility criteria only begins with the preface of documents of being registered. My lord, thereafter we say about an FIR. Now, my lord, kindly comes to the last paragraph of that page. It is also mentioned that all the complaints made by the patient party duly submitted to the different forum are full of contradiction and also misleading one with a view to malign the reputation of the nursing home with some ulterior motive. All on a sudden, around 2 p.m., the blood pressure became low. Then our RMO and sisters informed the treating doctor, Dr. G.K. Ghotok, as well as informed patient party about the patient's condition. Dr. G. Ghotok and Dr. J.C. Bormon appeared there, and as per their advices, we have given the medicines after medication. The patient responded well. Till 4 p.m., the patient was talked normally with her husband, which is self-explanatory in this complaint. Suddenly, the patient complained abdominal pain and was restless. Ward RMO and sisters immediately attended the patient, immediately called ICU RMO. The patient was quickly shifted to ICU. Rapidly, the patient went into shock and gasping condition. Treating doctor, Dr. G.K. Ghotok and anesthetist Dr. G.C. Bormon came to attend the patient. All doctors and nursing staffs rushed to save the patient. Cardiopulmonary resuscitation started. Urgent endotracheal intubation was done and the patient was put into ventilation. Patient was put on vein circuit with high oxygen flow. At 5:10 p.m., pulse and BP was not recordable. The whole measures which were taken at the material time for saving the life of the patient in front of the husband of the patient. The condition was grave and the husband also seen everything. All doctors were present at the bedside of the patient. Finally, all efforts failed. The patient was declared expired on 29th November 2019 at 5:35 p.m. Immediately, our ICU RMO informed the Barasat police station to perform the postmortem examination to ascertain the exact cause of death on 29th October 2019. Accordingly, the police came and talked with the patient party and they took the dead body for postmortem at North 24 Parganas District Hospital, Barasat, and also seized our original medical records in connection with the said patient. At that material time, we had two qualified RMOs, one of the general ward and the other for ICU HDU ward. Patient party has not paid any charges / money for operation and treatment, neither in advance nor after that. We have no medicine shop. Matara Medical Hall medicine shop has supplied all the required medicines and consumables for the patient party and her baby. Even the patient party has not paid any amount to that medical shop. The newborn baby was not taken by the patient party and we looked after the baby with proper medication for another 5 days. For that also the patient party has not paid any amount. Mr. Sanjay Sadhuka, complainant, has taken the baby from the nursing home on 3rd November 2019 by duly signing our register. It is pertinent to mention here that during her pregnancy period, no investigations were done in our nursing home. She used to check up by the treating doctor in his own chamber at another place. For that reason, no previous medical records are kept with us. At that incidental moment, patient parties did not complain against the nursing home, but after being motivated from some outsiders, they complained against the nursing home for some wrongful gain. Fourthly, it can safely say that prior to making any complaint by the patient party to any forum, the nursing home authority informed the matter to the police authorities firstly. So the question of negligence / malafide intention or any suppression does not arise against the nursing home authority. Finally, from the above discussion, we can safely say that there was no negligence or deficiency in providing service causes death of the patient, death of Momita Sadhuka, and there was no violation from our side in any provisions of the West Bengal Clinical Establishments Act 1950, and my lord, a prayer was made for exoneration. Now, my lord, Lordship would kindly, my lord, see, my lord, there is a complaint before the commission. My lord, there is a reply before the commission. Now, my lord, the complaint, my lord, speaks of disputed questions of facts. And my lord, the reply, my lord, there to my lord, is a my lord, counter to the disputed questions of fact. Now, my lord, if your lordship sees section 44 subsection 2 of the act. Now, my lord, section 44 subsection 2 of the act, my lord, lays down the procedures, my lord, in which the commission has to deal with this complaint. My lord, if a complaint is lodged. Now, my lord, kindly see section 44. Section 44 lays down the procedure to be followed by the commission. Now, my lord, may I place section 44? The West Bengal Clinical Establishments Regulatory Commission shall not be bound by the procedure laid down by the Code of Civil Procedure 1908, but shall be guided by the principles of natural justice and subject to other provisions of this Act and the rules made thereunder. The Commission shall have the powers to regulate its own procedure, including the place at which it shall have its sittings. The Commission shall, for the purpose of discharging its functions under this Act, have the powers as are vested in a civil court under the Code of Civil Procedure.
Okay, such a civil procedure limitation act.
Now, my lord,
also
kindly
has.
sees how does the commission deal with this complaint? Now, my lord, the commission, my lord, ought to have recorded, my lord, since it's a mixed question of law and fact, the commission, my lord, ought to have directed both the parties, my lord, to file their evidence, because, my lord, section, my lord, 44 subsection A, B, and C, lordship would kindly see, summoning and enforcing the attendance of any person and examining him on oath. B, requiring the discovery and production of any document or other electronic records and other material objects producible as evidence. C, receiving evidence on affidavits. D, requisitioning any public record. E, issuing commission for examination of witness or
Now,
documents.
what do you want?
But my
That
contention
means
is,
they are bound to take evidence.
but only thing is, when there
The
is
power has been given.
Matlab, power has been given.
Yeah.
It's a mixed question of law and facts. Now, what does the commission do? Commission says produce the nurse, produce the doctor before the commission. Now, my lord, we raise a contention that the nurse has left the duty, the nurse has gone. Now, my lord, the commission, my lord, without, my lord, asking them, my lord, to file their respective affidavits, my lord, both the complainant as well as the, my lord, in a very mechanical manner, my lord, imposes a cost of rupees 2 lakhs upon the clinical establishment. Now, my lord, the manner in which, my lord, the clinical establishment has been quantified the cost of rupees 2 lakhs, my lord, there is no breakup of that as to how, my lord, the commission has arrived at that amount. Now, my lord, if your lordship, my lord, kindly see section 33 of the Act, my lord, section 33 lays down, my lord, the compensation issue. Now, my lord, section 33 subsection 1A, which may extend to rupees 3 lakhs in case of a simple injury, which may extend to rupees 5 lakhs in case of a grievous injury, and which shall not be less than rupees 10 lakhs in case of death. So, my lord, my contention is, my lord, first is the commission, my lord, if it has to hold, my lord, the clinical establishment, my lord, guilty, because, my lord, I have shown your lordships, my lord, the commission cannot adjudicate medical negligence. The medical negligence has to be decided by this concerned state medical council. Now, my lord, if the commission has to adjudicate, my lord, upon the clinical establishment, my lord, the commission has to come to a finding that there was either a deficiency in patient care service on the part of the clinical establishment, or the clinical establishment has resorted to any unethical trade practice, my lord, which may include overbilling and others. My lord, that is not the case of the complainant. My lord, in the complainant has not raised a single issue saying that I have been subjected to a deficiency in patient care service on the part of the clinical establishment. Now, my lord, the commission, page 71, if your lordship sees, that is the first order, my lord, order dated 14th February 2020.
Yes.
Now, my lord, the matter was heard by us on the last occasion when we adjourned the matter awaiting postmortem report. The postmortem report has since been received. The same would confront the bedded ticket and OT note produced before us by the clinical establishment. We would direct the clinical establishment to produce the concerned nursing staff under whose care the patient was being looked after at the post-operative stage. We would request the concerned treating doctor as well as RMO under whose care the patient was being treated at post-operative stage to assist us on the next set of hearing. So, my lord, my contention is, if the patient party is not making any allegations with regard to, my lord, deficiency in patient care service or other factors on which, my lord, the commission can adjudicate upon the clinical establishment, but it was not the case of the complainant. My lord, the commission, my lord, has also not come to a finding that, my lord, there was any deficiency in patient care service on the part of the clinical establishment. Now, my lord, what does the commission do? the commission awards a compensation. Now the commission says that I shall await the result of the West Bengal State Medical Council to ascertain if the West Bengal State Medical Council, my lord, has found out any negligence on the part of the treating doctor.
Okay, okay, I have seen, yes.
Now, my lord, my contention before your lordships would be, my lord, the commission, while passing, my lord, the order impugned, my lord, has not at all followed the provisions of the West Bengal, my lord, Clinical Establishment Act on the score that the complaint before the commission was not at all maintainable, my lord.
Okay.
My lord, these are my submissions.
Yeah.
I appear for the respondent number 4, the complainant.
Respondent number 4. Oh, that is the complainant,
Complainant.
yes. And you?
Yes, my lord, I appear to the regulatory commission.
Oh. Yes.
My lord, kindly come to the order. My lord, my learned friend is challenging the order passed by the council. My lord, kindly come to the last part. My lord, they have accepted the order of that compensation and asked for, my lord, kindly come to page 74.
Yes.
74 last part. Miss Ranjana Learned Advocate appearing for the praise for reduction of the amount. My lord, if he accepts, then he should ask for reduction. My lord, they have already accepted the order and asked for reduction. Now my learned friend has come before this court filing the writ petition. This is number 1. Number 2, my lord, they have failed and neglected to bring before the commission, my lord, the treating nursing staff and the treating doctor. My lord, what has happened on 28/10? They have failed to produce the nursing staff and the treating doctor who was present during that incident. Well, they have failed. Kindly come to page 74. The nursing staff informed the concerned treating doctor he did not come at relevant time. He came to the that unfortunate death of the patient, my lord. They were asked to be produced. They were not produced. This is number 1. Number 2, my lord, on 29/10/2010, 2000. When the incident occurred, my lord, the doctor was not found present. Doctor means the doctor who conducted the operation on the patient. My lord, the nursing home was there. My lord, nursing home should have taken some care. Some care means if the doctor is not found, my lord, they should have contacted another physician who should come, and they did not do anything. That has been recorded, my lord. In the respondent number 4 lodged the complaint with the clinical establishment tribunal as well as with the medical council, and the medical council has heard the entire fact and has passed an order against the doctor as well as the clinical establishment. My lord. They say they have observed. Vichy. My lord, kindly see page 78.
Yes.
My lord, it starts from page 78.
Yes.
It is an observation by the expert opinion, Dr. Subesha Basu Roy. My lord, I will take your lordship to page 79. Paragraph 9 and paragraph 10. The most distressing factor was learned by me that the operating surgeon, Dr. G.K. Ghatak, or his assistant, Dr. Devashish Ghatak, did not come to the hospital to see the patient. When contacted by the RMO in a period of 6 hours, in the immediate post-operative period, when the patient was a 24-year-old woman, would have been served. This is an extreme act of inhumanity which was found to be shocking. Dr. G.K. Ghatak attended the patient when she died. No proper management was done. I am relying on this. No proper management was done to revive the patient thereafter in so-called megacity nursing home. My lord, there is a term used. My lord, I will not read the term, my lord, it's before your lordship. It says it's a human slaughterhouse.
It is the recording of evidence before the
It's
medical
the recording
council.
of evidence. The
My lord,
commission has, my lord, the medical
I am-
council has not decided it finally.
it has been decided
No.
finally.
My lord,
Yes.
No.
My
My
lord,
lord, may
they
I
have
say
challenged
this? The procedure under the Bengal Medical Act is and where, my lord, pursuant to which
Allow him to make submission.
And the medical council has passed an order and the doctor's name has been struck off. My lord, he has filed a writ petition which is pending before this court, before Justice Amrita Sinha, my lord, and an appeal has been preferred. My lord, the medical council order is final. My learned friend perhaps doesn't know that.
No.
My lord, in the meantime, what has happened, my lord, I am asking this question to myself. If somebody goes and being admitted in a nursing home, if that patient's condition becomes serious, if the doctor is not there, the responsibility belongs to the nursing home. They should call the doctor and attend the patient. For that, they are being paid. Here, my lord, nothing has happened to that sort. They only tried to cut.
Yes. May I submit, Millard? There are two things. Millard, the complaint says that there is a complaint against the treating doctor as well as the laches on the part of the clinical establishment. Now, Millard, if your lordship kindly sees who is the petitioner before your lordship, Mega City Nursing Home. That means when it has obtained the license, it is coming within the definition of nursing home. Nursing home, Millard, under provides Rule 33, rule medical staff, it says it must contain Millard, resident medical officers. My lord has got it. My lord, if your lordship kindly sees there. কোন বুকটা আছে জজ সাহেবের কাছে একটু দেখি কোন বই এই বইটা দেখতে দিন এটা হচ্ছে 2 পয়েন্ট আইপিডি মেডিকেল স্টাফ 2.3 একটুখানি 2.3 it's a rules.
Yes.
A pattern, my lord, it has been discussed how it has to be managed, the nursing home. Now, my lord, if your lordship kindly sees the order passed by the commission, there are stages of the order. My lord, section 38, I do not want to read further because, my lord, it has been placed before your lordship. First of all, the complaint would reveal a young lady was under constant gynecological checkup of the concerned surgeon at antenatal period. The lady was admitted in a concerned clinical establishment for delivery. My lord, now the issue comes. First, my lord, went to doctor. Periodic checkup was there. Thereafter, he advised to go to this particular nursing home where I will deliver the entire operation. The lady was admitted in the concerned clinical staff for the delivery was done by cesarean section at 9 a.m. in the morning. October 28, 2019, the female, a child was born and patient was shifted to bed. According to the RMO, now, my lord, part of the nursing home comes. According to the RMO, there had been fall of BP at about 1 p.m. that could be managed. However, the patient became critical and ultimately she went to in ventilation at 5 p.m. and died at 5:35 p.m. My lord, 1 p.m. it can be managed. Within 5 p.m. expired. What was the duty of the nursing home? Now, my lord, the court, the tribunal has observed. Today, clinical establishment is present. We have heard concerned RMO, Dr. Kaustubh Saha, the clinical establishment representative would contend during pandemic. The concerned nursing staff left the establishment. My lord, it cannot be. Because, my lord, there was a specific direction passed by in India that no nursing staff can leave the place. They cannot. Sorry, please don't interrupt. Please. Maybe.
Submissions at his will. Can he produce any document?
Allow you note down. You will get a chance to reply. Although short.
If I consider this way, that the nursing home, nursing staffs are not there, then there would have been a closure. Whether it was closed? No. Then, my lord, it was in operative condition. They cannot take the plea that nursing home, there are nursing staff left. In operative condition, rules provides while, my lord, operating the nursing home, there must be some consideration that is to be placed. Nursing staffs are to be there, RMO has to be there. That was not there. Now, during pandemic concern, now the treating doctor is not present. My lord, that is another part. Our experts on the panel have examined the medical records. My lord, panel, my lord, in the commission, my lord, there are specialist doctors who examines the entire records, and headed by the chairman, that is Honorable Justice Ashim Banerjee, who, as his lordship then was. And the post-mortem report unhesitatingly opined that death was due to antepartum hemorrhage from the caesarean section wound. The primary negligence, if any, would be from the treating doctor. Now in the medical negligence part, that my learned friend is contesting there. Ultimately, his license has probably ceased, I believe.
For 2 years.
Yes, for 2 years that we have been informed. For 2 years, for which the complainant has already approached the West Bengal Medical Council. We are of the view the clinical establishment also cannot absorb their, my lord, responsibility. Well, admittedly, when they are particularly there is an admission on their part, nursing staffs were not there. Who were there at that point of time when the patient expired? When patient is admitted in a particular, kindly see, when a patient is admitted in a clinical establishment and her condition is deteriorating, it is primary responsibility of the clinical establishment to take appropriate steps of her treatment. Fact remains, the concerned treating doctor never came to attend the patient. The treating doctor, my lord, he faced and he has been punished. And now, my lord, the writ petition was moved. That, my lord, the writ petition has been dismissed.
Pending for adjudication.
Yes, pending for adjudication, but no stay is there. That means his license is seized. Now, my lord, the complaint would contain the concerned treating doctor was residing close to the clinical establishment. The nursing staff informed, now the nursing staff informed the concerned treating doctor he did not come at the relevant time. Now, in one hand, the clinical establishment says that nursing staffs have left the nursing home. On the other hand, nursing staff, they are inform the clinical establishment. We have informed him he did not appear. He did not come. He did not come to the relevant time. He came after the unfortunate death of the patient. We impose a token penalty of 2 lakhs as against the clinical establishment. Why, my lord, 2 lakhs? Because, my lord, section 33 says, my lord, it has specified the nature. My lord, ultimately, my lord, death occurred on the day of the delivery. It's a grievous in nature. My lord, it would have been enhanced to 10 lakhs. But the commission did not do so. Only because of that, unless and until the medical negligence is established, where, my lord, it has been established, and, my lord, the particular nursing home has been indicated as a slaughterhouse, and that has not been challenged by my lord, this particular nursing home. They have admitted. They have not challenged the same before this court. When the medical council has observed specifically it is a slaughterhouse, then, my lord, not only this particular, my lord, order, not only that, it will be enhanced up to 10 lakhs. This is my humble submission.
Okay.
Very shortly. Now, my lord, first is the question of slaughterhouse. My lord, I do not know whether the West Bengal Medical Council in its final order has said it to be a slaughterhouse. It's the opinion of a doctor of the Penal and Ethical Cases Committee of the Medical Council. Now, my lord, what my learned friend has handed over, my lord, kindly sees, my lord, the procedure before the West Bengal Medical Council is a complaint show cause. Now, my lord, the Penal and Ethical Cases Committee, my lord, the complainant and the accused doctor, my lord, are present. There is, my lord, recording of evidence. Based on that evidence, my lord, the Penal and Ethical Cases Committee, they come to opinion. The opinion is now placed before the West Bengal Medical Council, who deliberate in private, and thereafter, my lord, the decision is passed. So, my lord, kindly sees the last page of what my learned friend has handed over. My lord, with the above observations, the file is placed before the council for arriving at a final decision.
Yes.
So, my lord, this is not the final opinion of the West Bengal Medical Council.
Okay.
Number one. My lord, second point is, my lord, so far as presence of concerned RMO and nursing staff, lordship would find, my lord, it was the case of the commission that that particular nursing staff had left the clinical establishment. My lord, that does not mean that there were no nursing staffs in the, my lord, clinical establishment. My lord, secondly is, my lord, RMO. My learned friend was trying to suggest that a clinical establishment, whether it be a nursing home, in terms of the definition of clinical establishment, there must be an RMO. We had an RMO. Now, my lord, fourth is medical negligence. I have shown your lordships, my lord, 38, my lord, third proviso to section 38. My lord, the West Bengal Clinical Establishments Regulatory Commission cannot adjudicate it at all.
Okay.
But it is only upon the State Medical Council. Now, my lord, the order of the State Medical Council holding the doctor negligent, my lord, cannot, my lord, fall upon the shoulders of the establishment, because, my lord, it is an act of the concerned treating doctor, my lord, my lord, what should I say, my lord? It is an act of the concerned treating doctor, my lord, for which he should be punished. But if the concerned treating doctor is punished, my lord, the clinical establishment has nothing to do. And now, my lord, kindly sees, my lord, from the reply of the, my lord, medical clinical establishment, well, it is all along the case of the clinical establishment that the concerned treating doctor was informed. Since the concerned treating doctor did not arrive, one Dr. Anirban Mujumdar was called. Dr. Anirban Mujumdar and an anesthetist was also called. So, my lord, my contention is that for holding the clinical establishment liable, my lord, there must be a specific allegation as to what was the deficiency in patient care services given by the commission. In the original complaint of the complainant, my lord, it completely lacks.
You have to. আসুন। The dispute involved in this pageant petition has its origin
Appear on behalf of the state respondents. State respondents.
Yes.
Nobody there was there in the yesterday also.
Huh?
Nobody was there in the yesterday also. Kindly dispose it of.
No, today you have adopted a resolution. Okay, not today. You are for the petitioner. Other side is not there.
I think not. Well, I've served already, but I don't know.
So not today, come tomorrow.
That is the,
Okay. Yes.
after this. Get,
Huh.
get, brother.
7,
Same.
8,
Yes, yes.
9,
I am for the petition.
The other side is not there. So not today, come tomorrow. Huh.
10,
Huh.
11, 12, 13, 14, 15, 16,
14. Your learned friend, other side is not there.
Bank of India.
Oh. আচ্ছা আইটেম নাম্বার 14 লিখুন তো যে learned advocate repenting the petitioner submit that the service upon the service is not complete. The service of the copy of the petition is yet to be effected upon the respondent. He takes for time to complete the service.
under 15,
15, not today, 16,
16,
not today,
17,
not today.
18,
18 Millard, I appeal for the petitioner. Well, I am only filing the affidavit in reply. And now Millard, kindly fix a date for here.
No, let your learned friend come
The copy may be taken into the record.
on that date, I said.
Oh,
You are for the respondent. Oh. Where is your beef? Will you do it?
Only filing affidavit in reply. Millard, kindly fix a date for hearing.
Oh.
I'm supplying the copy to you.
Have you got the copy?
No, not yet, Millard.
Oh,
I'm here and now. Then in one, I have to take the
আচ্ছা লিখুন আছে affidavit in reply filed on behalf of the petitioner is taken on record. ঠিক আছে, the copy of that reply has been handed over to the learned advocate. No, all are present.
So allegation against me, my lord, so my lord,
Huh?
I am the main respondent. Allegation of the writ petitioner against me, my lord.
Maybe all are present.
Because of
Yes, he is for Union of India.
Oh, so all are repentant.
Yes.
Okay, so place this.
Let us please to that extent.
90 এটা 19 18 here election process conducted by the West Bengal College Service Commission.
West Bengal?
College Service Commission.
Oh.
For the post of assistant professor in different subjects. Notification has been made in the year 2018. Following the guideline of UGC 2016. Now, thereafter a notification issued by the government of West Bengal regarding process of selection. 272 notification. Now, my contention are twofold. The private respondents who have been accommodated, but they are overaged on the date of application, that is 1st of January 2018. And in lieu of, if they are
Who is for the private respondent?
a private respondent has been served, or at least 3 occasions in terms of the order of the court, they did not turn up. So, my dear Lordship, already there are certain orders prior to that. 3 times, 3 different benches, it has been directed to appear.
Do it tomorrow.
No,
Let me place to some extent, we are spending some
because
time
of
to-
I have given my lord the recommendation against the my lord the private respondent in favor of the private respondents. So my lord, my learned friend has my lord taken a plea that my action is my lord illegal. So my lord, I have to give answer before this court. My lord,
Okay,
so-
private respondent is a party.
Party, my lord, but my lord, admittedly, it's my lord, despite service, my lord, private respondents
let
are
us
not.
proceed. Well, your Lordship is sitting.
No, my lord, I'm
Actually, you have adopted in the absence of any party.
Any
No,
party,
any party
yes,
means-
since they are not
this is
appearing, then your Lordship can
But this
take
is the
advantage.
exceptional case, my lord. Despite repeated occasion, private respondents are not appearing.
That is
That's
why.
true.
Okay.
Let us please. Let us proceed. We can spend
If-
some time with Lordship today because
After my lord making submission of my learned friend and me, if
Yes.
lordship has required my lord this private respondent necessary, then lordship can.
No.
I believe that it will not
No,
be
it
required.
is not.
His appointment has been challenged. His appointment has been challenged.
Yes.
Not the
Replacing him, you want appointment.
Yes, yes.
Mainly.
Yes.
If your pair is accepted, who will be oath sufferer?
That is correct. Do that, of course.
Be that as it may, my
Let
lord,
us-
if
let us-
lordship
let
can
us-
hear
He will suffer.
No.
He will also suffer.
Let
He
me
is
place.
the person who has been appointed, he will be oath sufferer.
I
Yes.
believe that after my lord hearing me, my lord, I believe that my lord the private respondent will not be suffered.
Okay, you please.
Get full Lordship. Now, the contention was there that on the date of application, that is 1st of January 2018, as per notification, they are admittedly overaged. One of the contentions. Second contention is this.
Yes.
If they can get the benefit of relaxation up to the age of 47 years, in lieu of that they were working in different organization privately, then their age relaxation to be up to 47 years in terms of the notification. So if they are coming within the purview of 47 years, they are within overage. In that case, they have been given relaxation up to 47. But statute says, in respect of the general candidate, then that person will not get the double benefit, reservation of the reservation. They are to get more than 55% in the eligibility criteria in respect of the academic college. But one cannot get the double benefit. This is one of the case of mine.
Yes.
Yes, Supreme Court categorically said there cannot be reservation over reservation. One cannot get the reservation twice. In one hand, less than 55 of marks as SC candidate. Secondly, overage age up to 47 years. They are to meet in that issue. Now, here another violation made by the authorities in respect of the selection process. Very vital question is this: whether the recruitment body can fix up the panel by themselves contrary to the statutory provision as well as the UGC guideline. I can show that recruiting body themselves fix up the score pattern.
Fix up the
Score pattern up to 100 of marks, how marks to be given in different manner head, which contrary to the state government notification as well as the UGC guideline frame for the post of assistant professor, how marks to be ascertained or score pattern can be fixed. Here, without following those guidelines, recruiting body must follow the statute or guideline framed by the state on UGC guideline. UGC. Here, themselves made this. That has not been disclosed at any point of time till my RTI application. Now they have come with the plea. I have filed a writ petition after the expiry of the panel. One cannot take advantage of their own wrong. I have taken in the reply that plea also. Unless I get sufficient document through RTI, then I cannot know where is my position is. And panel has been prepared only giving the name of the candidate without any breakup of marks. The Supreme Court categorically said in view of the latest judgment just few days back, to RTI, they are to give all the breakup of every candidate who have been given empanel. Otherwise, one cannot ascertain. I cannot ascertain where is my position. Giving the serial number by name, how can I know that less meritorious candidate figured in the panel without production? Different honorable single benches up to the division bench, they preferred an SLP. I shall show all dismissed that without backup marks, nobody can ascertain where is the position is. Therefore, direction was given to produce the entire panel with the backup marks. Till date, in none of the subjects, other subjects also, I have annexed in the reply also, they have not. They went up to the Supreme Court. Division bench will not affirm the judgment of the single bench. Review petition filed. During the pendency of the review, SLP dismissed, suppressed all these things. I shall come. That is why it is required to be heard. Give me some time. Now, another point, my lord, law settle. They have disclosed before the taking the plea before the Supreme Court that on the date of publication of the advertisement, whatever the vacancy notified to the commission, only those vacancies are to be filled up. Here, what happened? In different subjects, selection process may be different subject, but they have done in all the cases that after publication of the panel, even prior to publication of merit panel, after publication of merit panel, during the pendency of the merit panel, after expiry of the merit panel, all appointment has been given by recommendation. I have annexed in the reply also. Whether this is sustainable. Now, another point. Oh, merit panel has been prepared.
Yes.
And disclosed after I made an application through RTI with the marks of the other candidates. I can show before your lordship, I have annexed those. Not prior to. It is the duty of the commission for transparency, maintaining transparency. that all backup marks along with the panel to be published in the panel itself. They did not.
Stated in. Yes.
Now, I'm placing the case. Kindly see the advertisement. These are the issue to be decided.
Sum and substance of your case.
My lord.
Yes.
My lord, kindly come page 56.
Page?
56.
Yes.
Writ petition.
Hmm.
Lord, kindly sees the eligibility, column number 3.
Hmm.
The minimum eligibility condition contained in the advertisement are governed by the provision of the government memorandum. This memorandum of the government of West Bengal, they are to follow this memorandum. This is a government order following the UGC guideline. In the 727, it has been mentioned that this notification is being published following the UGC guideline. I shall show the guideline. Now, kindly come to assistant professor, next page. '57. Assistant professor of those subjects has been mentioned. Good academic record, at least 55% of marks or equivalent at the scale wherever grading system is followed at master degree level. This is the one of the eligibility criteria in the relevant subject, along with the applicability specified categories as explained proviso 1 of this tool. The candidate have cleared the national net set such and such. The assistant professor, all subjects are there. Now relaxation part, page 58.
Yes.
A relaxation of 5% may be provided to the master degree level for recruitment of assistant professor. My lord, kindly sees proviso 1. Just now I have placed 5% relaxation from my lord academic level candidate belonging to a scheduled caste, scheduled tribe, differently able, disabilities, and at least 40% above disabilities of other backward classes such and such. Now PhD degree 55% and 5% relaxation. Now age criteria, page 59, bottom.
Yes.
If the candidate is a SC candidate, they are to get 5% relaxation in respect of the academic marks. 50%. Not 55. In case of general, 55. In case of SC, ST, that the 5% to be reduced. That means 50% they are entitled to. Be happy. Now age relaxation, kindly see. Upper age limit is 37. 1st January of the year. That means 2018 of the advertisement. The advertisement and relaxation of 5 years for SC, ST, and 3 years for OBC. Here, first two candidates or age 47, I have mentioned how many days? 47 and 45, more than 45. Not up to 5 years means 42. Of assistant professor. Now, column number 2. If they come within the purview of CWTT and PTT candidate, that means temporary teachers, part-time teachers, and whole-time teachers in CW other posts. Then their relaxation 47 years. My contention, either of the clause, unless if you avail 47 years, then you are to be treated as general category. Then you cannot get the relaxation of 5% less in the academic. And if they have stated as ST candidate in their candidature, they have mentioned. Now, kindly come to 62. If someone comes from the other state, then they cannot be treated as OBC candidate or ST candidate. 62, third paragraph. Got it, third paragraph. The SC/ST candidate of West Bengal, they will get that relaxation. But the person coming from the other state, candidate of other state, will be treated as general candidate. One person domicile of Jharkhand, annex the documents. They have been, that person has been treated as well as ST candidate, relaxing the age. Now, I am the scheduled tribe candidate. My candidature is at page 69. My biodata has been
You
given.
are scheduled tribe.
I am scheduled tribe. Kindly see South Ali,
50, 50.
page 69. That is my
69.
biodata has been given
Yes,
to them.
yes,
Category scheduled tribe.
yes.
Date of birth 1188. Now I am next page 66. Qualified have been given prior to, and Lordship kindly come to. I have been called on for counseling page 72. Bablu Soren name is there.
Hmm.
1, 2, 3, 4, 9 column number Bablu Soren.
Yes, Bablu Soren.
Yes. Now, my lord, kindly see the nature of the panel. Page 79.
Page?
79. Provisional merit panel for the government aided general subject, South Ali subject.
Hmm.
Kindly see the category unreserved. First column.
Hmm. You are.
Yes, you are means unreserved. These 3 person has been given appointment. Guru Charan Sharma, Kundas Murmu, Narendranath Murmu. Kindly see there is no breakup of marks has been given. For making transparency, what is the position of those person, how they have got in academic or such and such. On the date of panel itself. Panel was prepared 27/5/19. Bottom. I find the date.
Yes.
But I made a RTI query. Nothing given. First appeal. Before the second appellate authority, they have disclosed. After consuming a lot of time, they have given the panel expired. On the date of kindly come to the panel itself, prepared by them through RTI, page 85. Mine.
Yes.
My panel, I scored total 54.87. Giving, this is the score pattern prepared by the commission itself. There they have made certain deviation from the panel score pattern prepared by the UGC. I shall show. In postgraduate, I have got 60.5%. As well as ST candidate. And there are percentage of marks MP, HS, and undergraduate 49 point something.
And those 3% got?
Yes, I am giving. And my lord, kindly see the page 90, that is the order of the first appellate authority to give those.
Guru Charan got 59.9.
Yes, my lord, kindly come to page 98.
Kunjo Das, yes, 55. And all are 55, more than you.
Page 98.
More than that, you got.
My lord, kindly come to page 98.
98.
That is the Guru Charan Murmu.
Yes, 59.9.
Scored 59. But in the postgraduate, 51.38. And that has been covered by interview and performance. And I got the interview performance less than those. Kindly see.
Internal performance where?
Interview performance 14.75. I have got 11. Now domain knowledge 5.75. I have got 5.5.
Oh.
They have covered those less marks by giving the interview performance and other marks given by them. And in the PG column, kindly see, they are not getting, that person is not getting 55 above. And it has been mentioned ST category, that name Guru Charan Murmu. ST, my lord, got it? And government approved PTT, relaxation 47 years. And according to my calculation, this person is aged about 43 years, 3 months, 29 days. That is more than 42 years.
In the reply, my lord, I have calculated. I shall show the paragraph. Just now, I am giving the feedback of that what they have done in this manner. Now, kindly come to date of birth of that particular person. 2974. Fourth, fifth column. Guru Charan Murmu, then
Yes, 74.
74. It comes to on 1118, 43 years, 3 months, 29 days. And that person, Murmu, academic, total score 23.4 out of 50. Interview on other performance, 36.5 out of 50. More than that of academic. Although, my lord, there is judgment against me in that score that I cannot challenge the expert's decision.
Yes,
It is
yes.
there. I know this. Ashok Jadav's case, 1985. But manner, kindly see the manner, how they have dealt with. Now, next person, Kunjo Das, 27 to 70.
Yes, yes, I have seen. Huh?
Yes. Now, he also less than 55, 52.6. And total score, such and such. His age of 43 years, 10 months, 14 days. Above 42. Now, next person, also 41 years, 5 months. But this person is to be treated as general because he is the domicile of Jharkhand.
Domicile.
I have annexed this. And in the form, he has made that column that I am the domicile of Jharkhand. Then he cannot get the relaxation of 42 years. He should be treated as general. And kindly see, in this column, his category has been shown ST. Kindly see column. Although he is the Jharkhand domicile. But he got PG in postgraduate 60. Now, my lord, kindly come to the score pattern that, my lord, I am just finding the score pattern itself. Score pattern ta ওদের score pattern ta কত pattern দেখাও না একটু ম্যানেজ করেছি 56 না তোমাদের যেটা না 56 না
107.
Score pattern of that particular they have followed in terms of the provision. I am giving this. That is the score pattern of UGC is 101.
50, 30, 20.
Yes,
50 হচ্ছে research,
yes.
assessment domain 30% and interview 20%.
My lord.
Yes.
This is contrary to UGC guideline.
This is?
Contrary to UGC guideline.
No, it is a Gazette of India.
My lord, taking page.
Page 121. This is our score pattern.
Achha.
Oh.
121 P16.
Yes, it is 121.
Yes.
They have given 50 for academic.
Now what UGC said?
Yes, page 101.
Research 30.
Yes, my lord, kindly see page
Academic
101.
record and research total 50%.
Yes, now kindly come
Now
to
they have
at page
APA, UGC.
108. 108.
Yeah, and
It starts from 107, appendix column 3, table double B. 108. It is for the, my lord, assistant professor. Academic 50. Assessment, domain knowledge and teaching skill 30. And interview 20. They have splitted it up that 30 by twofold. Research publication, it will come for academic, but they have given in the 30 column. Experience teaching, postdoctoral, domain knowledge, teaching skill. Domain knowledge is here, my lord, kindly see, has been given. Assessment of domain knowledge and teaching 30.
But they have included the research performance within
the
assessment domain, assessment of domain.
And UGC says should be in the, my lord, academic domain.
Academic code. However,
Yes.
total up to total research publication marks 1, 2, 3, 4, 5.
My lord, got it.
25.
Academic record and research performance, 50, included 50. And they have research publication in the 30 domain column,
30.
assessment domain column.
45. So what academic record, total marks fixed by them, total score fixed by them?
50, academic.
50, they have 50.
Yeah, they have 50. Only for academic. Up to
Academic.
PG, up to PG.
Up to PD, yeah.
Without taking
PhD.
research column in that column.
Oh, only this thing.
Yes, this thing. But that changes. Point 1 in the Muller selection process.
50 up to PhD.
Up to PhD, yes.
Yes.
Up to PhD.
So this is not up to PhD.
5, 10, 20, 40, 50, 60. 60, it becomes 60.
It becomes 60, if that is so.
60.
Yes,
Yes.
60
5,
PhD.
10,
5,
15,
5,
5, 10.
It is 80.
No, 5. My lord, can you see the 5?
Yes, 5, 5, 10.
Matriculation. Then my lord,
85.
HS 5.
Ah,
Then my lord, the UG, honors 5,
10.
10, general 5. So it's 10, up to 10.
10. Up to 10.
10,
Oh,
10,
wow,
20.
okay, okay.
10, 10,
10.
20.
Ah.
Then my lord, the PG 15.
Ah.
20 and 15, my lord, 35. Then my lord, the net or say 5. 35 and my lord, 5, 40.
And
then my lord, the MPhil 5, PhD 10. So it should be counted 10. So it's my lord, it's a round figure is 50. Only for this clarification for this, my lord, I am submitting. So my lord, academic is 50.
50.
They cannot.
Only they have erroneously included the research
Research up to
publication.
5.
They have assessed it separately.
That I shall, my lord.
Now, this is totally contrary to the UGC guideline. They are to follow because the 272 notification says UGC guideline to be followed in toto. They, being the recruiting authority, cannot fix up this score pattern. This is violation of the statutory provision. Entire provision. They cannot, Nazir Ahmed's case. If the statute says something to be done in particular, the lordship knows that. 19 PV Council, 1838, 270. They cannot departure L, full stop from there. And by virtue of that, experience column, if that is there, but suppose I got 5 journal published by me, experience 5. They are to give, kindly see the last published, per reviewed, UGC listed journal, 1 marks, postdoctoral experience, 1 marks, teaching experience, these are the up to 5. And on that score, the person posted 5 journal in the internationally, they are entitled to 5. They are, suppose that his score is less than that, even then he can be included in the panel, if that is scored. But it cannot be bifurcated in the allotment of the column itself. So therefore, filing this or following this, the entire selection process in my, and that has not been published till my RTI application ordered by the second appellate authority to be given to me. After getting this, I filed the writ petition. And now they are taking the panel has been expired. Therefore, I don't have any right to challenge before the court. My lord, kindly come to page 131. That particular person, Narendranath Murmu,
Yes.
category general, he's making the application as general. Commission has treated him
as ST candidate.
ST. But domicile, kindly see, state domicile Jharkhand. It is written there. By that particular person disclose this. Whether he can be accommodated and given appointment or something else. Cannot be in the panel itself. Justice Datta held in one of the judgment, Jayasri Das, if there are irregularities found in the selection process, even after expiry of the panel, or without having inserted in the panel, person has the right to be challenged. Because I do not know what is the panel is. The moment I came to know, I have challenged. Being the inclusion in the panel itself also I can. Justice Jyotirmay Bhattacharya's division bench also held to that extent. Only to the, if that is arbitrarily done. Now kindly come to their opposition. I have made certain averments in paragraphs. They have not dealt with specifically. All these averment has made in the petition. They have denied evasively.
Evasive denial.
Yes, that means order 8 rule 5. Your Lordship.
Order 8 rule 5. That be treated
1964
as a
Supreme Court.
admission.
Assumed to be admitted. I need not explain. 64 Supreme Court 3 judges bench 538. But I have made a statement categorically in paragraph 20, how the score pattern has been given. I have made a statement, specific statement in paragraph 39. The ineligible candidate has been given accommodation, thereby in the panel. Paragraph 39, 41. And they have not dealt with in the opposition specifically. I can show. Now in the reply, kindly see. Dual stand. One stand before this honorable court in respect of other subject, of course. In the Supreme Court, their plea was that particular panel candidate could not claim for giving recommendation since the that particular post where those Rentu and Rentu and another person will be accommodated since that particular post has been created during the validity of the panel, but not prior to the advertisement or publication of the panel. Therefore, their appointment could not be given. In one hand, they have pleaded before the Supreme Court in that manner only to misguide the, sorry, I cannot say misguide, take the plea. In another affidavit, before this honorable court, they say, yes, appointment or recommendation can be given for the recounseling person if the post is vacant due to non-joining or some other else during the validity of the panel. In some of the matters, after expiry of the panel, it was requisition before the commission, that person has been given appointment. And kindly come to the averment before the Supreme Court, what they have pleaded. Prior to that, I am reading some of the paragraphs of reply. May I read for your Lordship?
Yes.
8 or 9 paragraphs. They have
8
done,
or 9 paragraph you will read now.
Hmm.
You short brief.
short brief. Yes, it is brief. Shortly.
Yes, yes, yes.
But page 2,
Yeah.
B. Commission filed the affidavit disclosing the fact that the commission issued recommendation letter to the impanel candidate in respect of the post which were created after publication of the panel till the expiry of the panel. Even after expiry of the panel, vacancy reported to the commission has been filled up, thereby recommending the name of the candidate. That I have just submitted. Now D. The state government by notification dated such and such, the said notification API score pattern of the associate professor and column number 6, it is mentioned in the purpose recruitment of assistant professor that the recognized degree college of UGC guideline regarding API score pattern to be followed. Just now I have shown to your Lordship. But in no case the College Service Commission, being the recommending authority, can fix up score pattern to the recruitment viewers the state government notification as well as the guideline. The petitioner only came to know after the score pattern WBSC RTI reply is given to the petitioner. Only thereafter petitioner has approached the honorable court for filing a petition. Now E. WBCSC, being the recruitment body, cannot prepare the score pattern of their own to follow a recruitment notification such and such. Now H. The private respondent number 12 to 15 application under the ST category as per the advertisement notification dated such. The SSC considered their schedule type category recruitment process as well as the advertisement of private respondent only get the benefit of 42 years of the age relaxation as on 1/1. But on the dated 1/1/18, the age of the private respondent 43 years, 3 months, 29 days. In respect of the private respondent number 13, 43 years, 10 months, 14 days. Just now I have mentioned. And in respect of the third, Jharkhand domicile. Now, in respect of the I, that's PTT and CWTT candidate, they cannot, if they get the age relaxation 47 years, they cannot get the benefit of 55, relaxation of 5% of marks. That I have stated. Now, delay part I have dealt with as per their opposition that I have come after the expiry of the panel, paragraph 6. Only after getting the RTI reply, after expiry of they have allowed me
Panel to expire
panel to expire.
by
Therefore,
not giving reply to your RTI.
yes. Therefore, they cannot get advantage of their own wrong. Your Lordship sitting with Justice Chakraborty in Southern Haldar's Haldar, yes. Your Lordship dealt with. But I can cite that judgment. Respondent cannot take advantage of it. They are not for making a delay. And latest judgment, delay is not the fatal if the arbitrariness, irrationality is there. The Boisakhi Mukherjee judgment passed by Honorable Chief Justice in respect of 26,000 matters. Dealt with. Delay point has been discussed there. Now, kindly come, their averment before the Supreme Court in that matter itself. Internal page 14 of my reply, paragraph 9. This is the affidavit filed by the commission itself to deny the getting recommendation of that particular Rentu Vishwas.
Internal page
14, running page 14, internal page 4 of their of my reply.
Yes.
Paragraph 9, my lord got it. What is the panel?
Yes.
14, 1/4.
Yes, yes.
In the present case, the respondent is claiming because of the fact that division bench affirming that single bench judgment directed them to recommend my client. I had the occasion to appear before both the benches in that particular Rentu case. He is claiming one vacancy occurred due to the death of the person which admittedly was not reported to the college authority to the office of the applicant during the validity of the panel, and other vacancy occurring due to the transfer and not also reported to the commission who perform and manner college authority to the effect that applicant during the validity of the panel in subject, all of course different subject accordance with the regulation to 2012. Thus, the applicant could not have added any vacancy not reported during the validity of the panel and recommendation in favor of the candidate. Now, it is submitted in absence of the validity of complete requisition, cannot add any vacancy on validation of the vacancy requires as per ascertainment of the compliance of the reservation policy in terms of the 1976 rule. Now, they say it is stated that under regulation 5 of regulation 3, the commission all occasion always notifies the cut-off date and official website which vacancy requisition are accepted against the particular advertisement. In that case, they are saying advertisement. And for particular selection, cut-off date always prior to publication of the provisional merit panel. It is their particular averment prior to the provisional merit panel in respect of the advertisement. 12 also prior to the publication of the provisional merit panel. They say. Now, kindly come to running page 29. In respect of another matter, to defy the claim of that particular writ petitioner, stand taken by 12.
Yes.
With reference to the allegation made in paragraph 24, 25, 26 of the petition, I state those are matter of record and I deny, which has not record. I state that on the basis of vacancy position, counseling empanel candidate took place according to the serial number such and such. There was no suppression of any candidate as such, the petitioner cannot make any grievance regarding the counseling. No candidate below the serial number petitioners have been recommended. All recommendation candidates above the serial number of the petition. I state, kindly, this is the vital one. I state the recounseling took place in the respect of the vacancy which occurred due to the unwillingness of a recommended candidate from the panel to accept the recommendation to refuse to join the post due to the date of recommended candidate. Recounseling took place for the benefit of the impanel candidate, whether they can do this after panel is published, they can make any accommodation too. Now they are saying, yes, I can during the validity of the panel, even after expiry of the panel. I shall show the documents and even after expiry of the panel, requisition sent, appointment given. I deny and incident reconcile beyond the purview of the regulation. Now another averment, running page 32. Page 9 of their paragraph 13. I
Yes.
deny and dispute from the fifth line of that particular averment, paragraph 13. I deny and dispute that in view of the recounseling being carried out, it shows the provisional merit panel are still valid and publication of subsequent notification is an arbitrary action and state authorities within the earlier selection process is still continuation as submitted to all. I state that recounseling took place during the validity of the lifetime of panel prepared on the basis of legal selection process initiated by publication such and such. And you see the contrariness. In Supreme Court, they are saying, no, no, no. Prior to publication of panel, all posts to be filled up. And here, even after, during the validity of the panel, even after expiry of the panel, it can be done. Now, some of the person, I have annexed those documents, they will clarify this. That requisition sending page 44. In those cases, panel expired prior to in the year 2020.
Yes.
Date of creation of vacancy 8/3/2021. Date of requisition 22/11/2021. Appointment given 10/1/2022. Date of joining. Now, just prior page kindly come. Panel when published. Just page 43.
Yes.
Date of publication of panel 5/3/2000. Then panel valid for 1 year in terms of the regulation 2020-12.
Yes.
Requisition sending 8 March 2021, even after expiry of the panel. Panel expired 5/3/2021. That creation of vacancy on that date after expiry of the panel. Now they cannot say that I am late. They will let them say, and I shall show the judgment later on.
No, you produce, you conclude which judgment.
Now, your lordship is of the mind that the selected to be served and heard. In this judgment, just this is 2025 SCC online SC 280 Anit Jadav's case, considering the allegations of other things, Supreme Court held that if the selection process based on something irrational or irregularities, in those cases, always selectee cannot be made parties. It is a Jharkhand selection process was there.
Paragraph.
Yes, paragraph I am telling. Paragraph 30, 31. 29.
Yes.
Now,
Yes. Next,
on
next.
7th of February 2025, in respect of the RTI matter, Honorable Supreme Court categorized even on the dismissal of the SLP that in respect of following transparency in the public selection process, break-up marks is necessary.
Copy maybe hand over, otherwise, my lord, I cannot deal with this. Well, before that, my lord, my learned friend placing the all judgments, my lord, kindly hear me as a facts. Then, my lord, lordship kindly hear my learned friend as a, my lord, the legal point and the judgment. So I can deal
No,
with
yeah. One matter, yeah. For how many days?
uh,
Numbers of matters are pending in this court.
that's true, my lord, but I
Yes,
lordship
you
has
have
to be
kindly cease.
Only here the proposition.
Yes.
Here proposition that always selectee is not to be made party in every case.
In every case.
It is the proposition.
Proposition.
Okay. Hmm.
Here I have made
otherwise, my lord,
And
This
it
is
is
the
this
proposition.
judgment proposition is
in respect of the public selection process,
Uh.
but for following the transparency, breakup of marks of individual candidate of selectee
backup
is to-
calculation of the score or marks. ঠিক আছে?
they have not done.
It's to be given.
Is to
It's to be.
So that I can know where is my position, whether the person less meritorious candidate got the appointment, I am not, then I am not able to know.
Yes, yes. Next,
That
next.
copy maybe sir, so I can.
একটাই কপি আছে আমি দিয়ে দিচ্ছি।
A unreported judgment.
Yes, I shall give. I shall give. And one notification that I have relied on.
One
notification of the government following the recruitment rule. That is at page when I'm giving that. Kindly give me 1 minute time. That UGC guideline to be followed. They have not followed in terms of that 727 notification. Oh, really? Small UGC guide. কোনটা? হ্যাঁ। তাই আসবে। Let him submit.
Yes, yes. You give the after panel, the judgment after panel.
After panel.
After expiry of the panel. Sorry, after expiry of the panel, that judgment.
That can be entertained.
Yes.
College Service Commission matter,
Okay.
Single bench, honorable single bench held. They took that plea also. That is also after expiry of the panel. And appeal preferred, appeal dismissed. This is in respect to another subject. They have taken that plea, citing some judgments, and I'm never grateful to that honorable coordinate bench. His lordship asserted certain judgment I did not cite. The judgment 2019-12, my lord has given himself.
Yes.
Paragraph internal page 10, running page 10.
Yes.
Here, some person has been given accommodation to a particular college which is not commenced for that. Now, I am being the next panel candidate, could have been given accommodation. That has not been done by virtue of a mistake or wrong information to the School Service Commission. Ultimately, I have been accommodated in another post.
Okay.
After expiry of the panel, writ petition filed.
Okay. Next.
Next, nothing.
Okay.
Lord, I appearing on behalf of the West Bengal College Service Commission. Lord, kindly, come to the prayer of the writ petition first. Whatever my learned friend has submitted, whether it is there within the pleading or not, my lord, I have to place before this court. Kindly come to prayer of the writ petition first, my lord, page 48. The writ in the nature of mandamus holding that the notification 727 dated 26 June 2018 is ultra vires to the UGC guideline on 11th July 2016 in respect of API score pattern in respect of the appointment of assistant professor in the government of Edit College. So his ballot first prayer to declare the ultra vires of the government notification. Second is the writ in the nature of mandamus commanding the respondent to rescind and or cancel the entire selection process in connection with the advertisement 1/2018 as well as the merit panel in respect of the each subject in respect of recruitment of assistant professor in the aided degree college. So the second prayer is cancellation of the advertisement and the selection process in merit panel in every subject. Then, my lord, the writ in the nature of mandamus commanding the respondents to rescind and or cancel the entire selection process connecting the advertisement 1/2018 as well as the merit panel in respect of each subject. Consequently, all appointment in respect of respondents, professor in responsibility. The third prayer is the declare as a, my lord, the null and void of the selection process and consequent of the appointment in every subject. So, my lord, my first prayer, if the writ petition is ultimately succeed by learned friends, so my all the appointments in respect of recruitment in the year 2018 by dint of advertisement 1/2018 of the 52 subjects, and my lord, the all recommendation near about 3,000 candidate has to be made party. Otherwise, my lord, the opportunity will not be given to them to defend them to my lord before this honorable court. Because of ultimately, if the court has declared that the selection and my lord, the notification declared as the ultra vires, then my lord, the appointment given to all the candidates has to be given opportunity. So this is the first three, my lord, the crucial writ petition which my lord, my learned friend has my lord filed and prayed for mandamus. Then my lord, kindly see the pleading of this writ petition. My lord, the first pleading, the paragraph 8. That the writ petitioner states that although the commission is the primary responsible to select candidate for recommendation to the post of assistant professor principal, but such selection process warrants to vivid and the comprehensive assessment of the candidature of the respective subjects. In other words, the details and vivid comprehensive test of the eligibility for the appointment of person of the assistant professor has to be through the elaborate assessment process. Arrangement has been made to the conduct of such assessment produced through the examination conducted by an examination, which is my kindly noted, an examination conducted by UGC, namely National Eligibility Test. Similar arrangement has to be made. But the first there, the statement he has made, the first there, the allegations against the College Service Commission, paragraph 10 first. The West Bengal, the petitioner states that the University Grant Commissions, which is central agency incorporated under a central act, namely University Grant Commission Act and the West Bengal College Service Commission, hereinafter call for West Bengal CSC, in short WBCSC, incorporated the West Bengal College Service Commission Act 2012, and the never intend to act or conflict with each and other, but through the harmonious cooperations with regard to guidelines of the recommendation UGC and or the selection embolded therein the specific obligation to select person those appointments of the West Bengal College Service Commission. The College Service Commission is the never intend to empower with the power to disregard or disobey the guideline of University Grant Commission, since two bodies having regard to the respective duties in conflict with each other. So, this paragraph, their contention, the West Bengal College Service Commission cannot neglect or disobey or my lord disregard to the central agency, which is my lord UGC, has my lord formulated a law. Even that, notwithstanding, there is a statutory act, because College Service Commission has my lord, conducted the selection process and my lord enjoy the power and function based on statutory act, West Bengal College Service Commission Act 2000, which is my lord enacted by the state. Then my lord, your petitioner says that the College Service Commission, through the notification dated such and such, advertisement so and so August, initiate application from the Indian citizen of recruitment to the post of assistant professor, different subject discipline, the different state aided college, general degree college, West Bengal. So this is the notification of the state government. My lord, may I, my lord, come back the notification? What the notification first? My lord, my duty is being a statutory authority, my lord, power holding under Section 8 of the State Act, West Bengal College Service Commission Act, to conduct the selection of the West Bengal assistant professor and my lord, the principal and librarians. Apart from that, we have no power, and only the power is my lord, limited to extend to my lord, conduct the selection process and my lord, the eligibility candidates who would be my lord, the participate, and after conducting that selection, my lord, we have prepared a merit list. Then my lord, we shall recommend it as per the notified vacancy. And what is the notified vacancy? I shall come back with the regulation. What the regulation says. Then my lord, the West Bengal College Service Commission will start the selection process based on government notification. Unless the government has notified and my lord instruct that now you start a advertisement and my lord issue conduct a selection process. Now lordship, kindly come to the notification first, which my lord, my learned friends, the first prayer to declare as ultra vires.
Page 56.
Page 50, no, that is my lord advertisement.
Oh,
that is advertisement. My lord, I'm coming, my lord.
Petition at page 113.
Yes,
113.
113. 113. That's you has not got it, my lord.
Yes, yes.
The notification issued by on the state of West Bengal, the Higher Education Department, on 26 June 2018. So my learned friend's submissions was that the assistant professor score sheet has been fixed by the state government. Despite that, the College Service Commission has, my lord, violated. My lord, my learned friend has failed to show before this court whether the notification prescribed for, my lord, manner of the score sheet has to be fixed by the state government. My lord, my kindly see the notification 1. My lord, firstly, my lord, I am placing the notification first. Consequent upon issuance of the University Grant Commission, my lord, the notification dated such and such 2010, and subsequent amendment thereto of the so and so, the appointment teacher and academic staff, the University College Service Commission, the maintain standard higher education, 4th amendment regulation so and so, the state government is considering for prescribing revised rule for recruitment of assistant professor and associate professor in the state aided college for the same time. After considering all these aspects and also taking into consideration of the local condition, the governor is superstition of the department earlier, so and so, the previous order hereby placed to direct the following eligibility criteria, qualification, norms, direct recruitment for the post of assistant professor and associate professor of the state government, state degree college in West Bengal. Plus you have got it, first paragraph and second. Then my lord, the kindly see the post. The post for only assistant professor and the associate professor in different government aided college. Then my lord, kindly see the method of selection. The by selection, the direct recruitment through the West Bengal College Service Commission, the government aided college. Then my lord, the qualification, age has been fixed by the state government. My concern, my lord, I am the concern because the College Service Commission had recruited in this by dint of notification only for assistant professor, no associate professor. Associate professor is the direct recruitment by the concerned college, not by the College Service Commission. Then, my lord, kindly see my learned friend, which was trying to hammering before this court to fix this, my lord, the score pattern by the state government that is not in relate to assistant professor. This is absolutely associate professor. Kindly go page 118. The minimum score for API for that, Lordship has got it, my lord. 100 at the bottom, my lord, 118.
Yes.
118,
Yes.
my lord, bottom. The minimum score for API for the direct recruitment of associate professor in the college in colleges to the to be considered along with the other specified eligibility qualification stipulated in the regulation. There is no specification in respect of fixing up the score pattern in respect of assistant professor. So my learned friend contention for relying that associate professor score pattern would be, my lord, followed by the College Service Commission in respect of assistant professor selection. My humble submission before your lordships is absolutely incorrect statement. Then, my lord, kindly see the advertisement. Page 56. Page 56 is the advertisement based on notification issued by the state government. Kindly see the applications advertisement which was published on 16 July 2018. Well, the first, kindly see the paragraph eligibility. The minimum eligibility condition contained in the advertisement are governed by the provision of the West Bengal government notification 727 dated 26 June 2018. The commission, however, can introduce, my lord, kindly note it,
Additional parameter, yes.
introduce additional parameter in regard to the select candidates of the her merits as laid down in the above mentioned regulation. Therefore, the mere position of the eligibility does not confer any right an applicant to be selected or empowered. Then, my lord, kindly see in the advertisement, we have specified that. Paragraph, my lord, page 62A. Yes, my lord. Before that, my lord, lastly, kindly come to 61.
Yes.
This is the part of this advertisement. My lord, paragraph 61, information and instruction in the column number 3.
Yes.
The recommendation procedure will be based on simple merit cum preference system of counseling. For further details regarding the recommendation process, the West Bengal College Service Commission manner of selection and recommendation of person for appointment to the post of assistant professor, principal librarians of the and re-recommendation for person of appointment to the post of assistant professor regulation as amended from time to time be consulted from the commission website. So, my lord, we have indicated in our advertisement, we shall conduct the selection process as per regulation 2012, which is, and that regulation is available in the website. Kindly come to page 62A. Column number 19.
Yes.
For any further query regarding application, selection and recommendation procedure, please refer the West Bengal College Service Commission manner of selection person for appointment the post of assistant professor, principal and librarian and re-recommendation regulation as amended, Procedural website. So everything has been in website and it has been described and incorporated in the advertisement at the time of advertisement. So any person who by intent to apply or is applied or participated, he can see all the regulations and which procedure has been adopted and maintained that has already been in the website. Despite that, the petitioner has applied. So it is presumed that the petitioner has followed and perused all the regulations and thereafter he applied. I believe so. The next step. Based on this advertisement, kindly see, before advertisement, kindly see another. Kindly, again, my lord, I am referring the page 56. Lordship, kindly, my lord.
Yes.
The vacancy, which my learned friend has, my lord, argued, the vacancy is cut-off date and, my lord, the others, the criteria has not been maintained or, my lord, violated by the College Service Commission. The vacancy calculation shall be done in accordance with the terms laid down in the West Bengal College Service Commission manner of selection of person of appointment to the post of assistant professor, principal, or librarian, and re-recommendation of the assistant professor. The vacancy cut-off date and the exact number of vacancies subject-wise, category-wise, and college-wise will be notified before publication of the merit panel. Before publication of the merit panel. The Commission's responsibility is restricted to accord completion of the vacancy as reported by the colleges, and the Commission is not responsible for any error in reporting or vacancy from the end of college. The Commission will not be responsible in absence of vacancy under any category of the vacancy for non-receipt of the requisition for any state of aided college. So the vacancy to be notified before publication of the merit panel, and that has been specified in the regulation, and that regulation has already been there in the website, and we have indicated in our advertisement everything has been website. Kindly follow this one. And if there is a vacancy as not reported by the College Service Commission, the College Service Commission will not responsible, even despite the advertisement, even despite taking interview. If there is no vacancy, the Commission will not be responsible. Then, my lord, the method of selection, whatever, my lord, prescribed and specified in the notification issued by the government of West Bengal on 26/2026, the total we have incorporated in our advertisement. Then, my lord, kindly again, my lord, lordship, I am requesting before lordship, kindly again come to the notification which has, my lord, published by the state government. In respect of, my lord, the assistant professor, the academic qualification has been specified, method and the reservation, everything has been specified. Then, my lord, kindly see the assistant professor. Page 113.
113.
Advertising.
Yes, yes.
The assistant professor.
Yes.
Well, the first, consequently good academic record with at least 55% marks or an equivalent grade in the a point scale wherever guiding system is followed, and the master degree level in the relevant subject along with relaxation applicable to the specified category. Relaxation is applicable for the specific category as explained in the proviso 1 of this rule. Then, my lord, the candidate must have been cleared national eligibility test conducted by the UGC or USCSIR or similar test, my lord, accredited by the UGC, so and so, so and so. This is the first two criteria or the primary criteria. Then, my lord, kindly see the proviso 1, page 117.
Yes.
This is proviso 1, the relaxation, which, my lord, I have just, my lord, referring that the relaxation, reservation has to be followed in particular category. The relaxation of marks for direct recruitment, assistant professor, associate professor. The relaxation 5% may be provided at the master degree for the candidates belonging to a scheduled caste, scheduled tribe, different able person with disability having at least 45 of the above disability and the other backward classes. So there is a relaxation clause and it has been specified by the state government, and being a statutory authority, I have to follow by the state government notification. Then, my lord, proviso, I am not, my lord, other proviso is not applicable in this case. Then, my lord, my lord, a PhD degree. My lord, the next, the PhD degree holder who have been obtained their master degree prior to September 1991, the minimum qualification of 55% for relaxable by the 5% from the 55 to 50 at the master degree level. Then the eligibility marks of 55% marks or the equivalent grade points of so followed by the relaxation 5%. Yes. These are the relaxation clause as per, my lord, the proviso 1. Then, my lord, kindly come to page 119.
Yes. Age, yes.
Age. The upper age limit is 37 on 1st January of the year of the advertisement. And that is in respect of applicable in the general category. Then, my lord, and relaxation up to 5 years of SC, ST and 3 years of OBC category, non-criminal year, candidate for the post of assistant professor. Then, my lord, the disability able candidates, except in the post of physical education, are entitled to an age of relaxation of 10 years. The age relaxation 5 years is applicable to the candidates possessing doctoral degree. Age limit for the post of associate professor is not relevant in our case.
4.
Yes, my lord. The 4 is very important for our case.
For
the approved part-time teachers, PTT, and approved contractual whole-time teachers, CWTT, and defined in the West Bengal College Service Commission Act 2012, the upper age limit for the applying for the post of assistant professor is 47. And the 1st January 2020 advertisement, subject to the same principle and quantum of relaxation as mentioned above, clause 7, which will also be counted from the on the basis of 47 years of those for those categories of the candidates approved PTTI WPTC. So there is a category also. Got it, my lord? My lord, the 7.1, it has been specified relaxation also be applicable to 7.1 category. So if, even despite notwithstanding, my lord, the relaxation has been given, he also, because of, my lord, the SC, ST, OBC relaxation in terms of, my lord, the constitutional right. Lordship knows better than me, my lord. And this provision has been incorporated and, my lord, given to, my lord, that contractual whole-time teachers to participate in the, because of these are the teachers, initially the history, I am just giving a short fact. Initially 2001, my lord, the college service, the West Bengal college dearth of teachers, which has not been, my lord, given by the state government by selection of the college service commission. The school, the particular college was, my lord, appointed them and giving their remuneration from their own fund. And they have, my lord, spent their prime time of life with a whole-time, part-time contractual before that college. Thereafter, 2019, the state government has, my lord, notified that yes, their service has been secure up to 60 years with the decent amount, not at par with the regular appointment and the regular professor. 30,000, 37,000, more than these are the category, 3 category has been fixed. But they are they want to participate in that on a regular process. They want to be a, because of so a series of matter has been filed that equal work, equal pay. They have filed that we are also giving a similar work in the college, but we are not getting the similar facility. That's why,
So one ST candidate or one SC candidate who is a part-time teacher or contractual whole-time teacher, in that circumstance, the upper age limit would be 52.
Yes, my lord. Subject to correction, and that is the law, we have to accept that. Unless they have, my lord, challenge and set aside.
And a para teacher, part-time teacher and whole-time teacher from other state also, they are entitled to get 7
I'm coming, my lord. I'm coming, my lord. My learned friend point that they are not domiciled. Those, my lord, the private respondents, my lord, my learned friend has referring and, my lord, made them party. Whether they are domiciled or, my lord, within the state, I shall, my lord, produce all those documents, my lord.
So they are the Noren Murmu. Noren Murmu only domicile.
That is
from Jharkhand.
Yes.
From Jharkhand. You are disputing this.
I'm placing, my lord. Everything I have, my lord, I shall, my lord, produce all
Okay,
those.
okay. Beep.
So, my lord, my first point of, my lord, my learned friend, that whether the person who has given the SC category relaxation, whether he is entitled
to again the benefit for being para teacher or central such and such.
My humble,
according to him, double.
Yes, my humble submission, once the state government has given the benefit, the college service commission
has got no.
And the same, well, the paragraph has been incorporated in my advertisement. Can you see that in my advertisement?
Yes.
So there is no dispute in.
That's enough. Now you clarify that
Yes.
from Jharkhand. From Jharkhand.
Yes.
The person Narendranath Murmu, who has
Yes, my lord.
a man of Jharkhand,
Yes,
has appeared.
This is the first point. Can you see my learned friend, my lord, placing page 131.
Yes.
131 that Narendranath Murmu is a domicile. Whether he has got the benefit SC category or, my lord,
he would be general candidate.
As per his statement, the general, obviously, my lord, my statement, advertisement also said.
Yes.
He should be treated as a general category.
Yes.
Despite that, my learned friend says he has been treated as a SC category. Well, can you see the recommendation whether we shall treat it as general or ST? Well, can you see the recommendation and the
yes.
Well,
as unreserved candidate.
I shall answer to that. Let him.
I shall play.
And he is para teacher or part-time teacher.
Yes, I shall. Everything I have that in the state.
So what prevented you to annex it with your affidavit in opposition?
No, because of, my lord, these documents, where from my learned friend has got it? Who has got it? Facebook. Am I the authority to everything to deal this? Whether he has produced the fake documents, am I bound to? My humble submission, no. Because
you
of
are not bound to give
each and every point,
to him, to the court.
no, because of he has documents relied, which is prima facie is my lord doubting.
You by
I have my lord paragraphly I have dealt with this.
Okay.
Then my lord, kindly see what is my learned friend submission first. That I have given the private respondents over as candidate. Lordship, kindly see the date of birth of my lord, the private respondents, my lord Narendranath Murmu.
এই দিন তো ওটা ওই যেটা
His date of birth, my lord, 24th
24th
July
July
2076.
1976.
Yes, my lord. My lord, kindly see the
1/1/2018. Huh?
18.
18.
18.
Yes. So
Whether is
on
below,
that date,
on that day, my lord, the calculation within the 41 years 5 months. Because the the candidates my lord will get relaxation from my lord my lord statute of my lord the PTTI 37 and my lord 10 years.
47. Yes, yes. If he becomes a PTTI or that, he will within the upper age limit. Yes.
My learned friend says that despite himself declare that a general, how the petitioner's name will be appear in the ST? Because of my lord, the petitioner is a scheduled caste candidate.
But was treated as a general.
Yes.
Yeah. Undeserved candidate.
Undeserved.
Okay.
But firstly, he should be treated as my lord, his own caste. We have not given the other benefits. Benefit in respect of selection, which should be treated as general. That's why we have treated as general, and we have recommended him as a treated as general. Next, I believe that at this point I have satisfied your lordship. First point, your lordship has asked me to satisfy this. Then, my lord, kindly, how the my learned friend has specified that the Kunjo Das has been recommended. Where from he got it? Kunjo Das has been recommended. Respondent 13. He said that the petition respondent number 13 has been recommended. Where from he got this paragraph? Evidence.
He may
But the Kunjo Das has not been recommended.
For the circum, he has made some wild allegations. But
in the whole writ petition is wild allegation.
But
whole writ petition.
Court invited a affidavit in opposition from you.
Yes,
and I think the document you could have brought this back and a document.
Documents, my lord, the second list, my lord. Third is Narendra Murmu. Narendra Murmu, I have first is Guru Charan.
Okay, that document, first document you produced that Narendra Murmu was recommended as undeserved candidate. Give that document. No, you just handed over. Yes, hand over to me.
And my lord, the next
and
page
regarding Kunjo. What you wanted to say?
Kunjo has not been recommended. Kunjo has not been recommended.
Kunjo has not been recommended.
We have not given.
Who have been recommended?
And another is the Guru Charan Murmu. Kunjo has not been recommended, my lord.
Kunjo has not been recommended.
Yes, my lord.
From this document, it would be evident.
Yes, my lord, because of unless
so Ramanuj Mukhopadhyay, Saurabh Sarkar,
Well, this is,
Kunjo Das Murmu, Saheb Ram Soren.
no. Kunjo has not been recommended. Kunjo is the PTTI teacher, and my lord Kunjo's application and my lord the documents who is my lord evident that the Kunjo is a PTTI teacher. That's but Kunjo has not been recommended. Unless we have my lord recommended, how can I produce before this court that recommendation has been made in favor of the Kunjo? Kunjo doesn't recommend it. Despite that, my learned friend has made party and make allegation the
Now,
person.
who ultimately have been
Only my lord Narendra and my lord the Guru Charan. Guru Charan, I am giving my lord whether the Guru Charan is domicile or not. Kindly see that.
Guru Charan and Naren.
Yes, my lord. Respond number 13 and my lord, 12 and 14.
Okay.
Kindly see the recommendation of the Guru Charan. Yes, my lord. My learned friend allegation that Guru Charan is the domicile. Kindly see my lord, the application first.
Guru Charan or Naren.
Sorry, no. Naren, Guru Charan both. They are my writ petition. He say my lord, relying one my lord, documents in the writ petition. Narendra is the domicile. And my lord, the other paragraph and the allegation, respond number 12, 13 and 14 are all the domicile. Kindly see the documents.
No.
First, my lord, kindly see Guru Charan Murmu, category scheduled caste. My lord, date of birth 12 September 1974. My lord, 2nd September. Then my lord, the permanent residence. I believe that within the
Bengal, yes.
there is no domicile. Then my lord, kindly third page, whether he is a PTTI teacher or not. PTTI is the himself, he has my lord, the Guru Charan has my lord place. Then my lord, his recommendation has been made in favor of your category. Then my lord, his certificate of my lord, the ST. ST is within the state. Then my lord, the concerned college has my lord certified that he is a domicile PTTI teacher in terms of the West Bengal State Act. And my lord, the,
Got anything in reply?
yes, my lord.
By 3 minutes.
আচ্ছা আপনি নিয়ে নেবেন three recommendation letter produced by them is taken on record.
Yes,
Cannot be. That is the another. Kindly see the over here submitted during the half an hour. Whether any pleading in his opposition,
yes, my lord,
annexing all these documents,
not necessary.
and pleading to that extent has been made or not.
Now, kindly see my
My lord will not go by any submission beyond the pleading. This is a settled.
Yes,
principle.
my lord, lordship kindly, my opposition kindly see the opposition.
May I read the entire opposition?
No, lordship, when my turn has come, my lord,
Okay, it would be looked into. The three recommendation letter, how you will prejudice?
I cannot defend in my reply because I have already used the reply. I cannot reply against the opposition, then again reply. I cannot.
What actually recommended? It is the real fact.
Whether it kindly direct them to then production of
very well, my lord. I shall my lord,
Cannot-
place by a
cannot
supplementary
be.
affidavit.
Cannot be.
Tomorrow I
Cannot
shall
be.
produce by
Cannot-
supplementary affidavit.
Now, my lord, kindly
Okay,
come.
আপনি দিয়ে দিন তো yes.
If that my learned pen, if my learned
I
pen has
cannot
Okay, you produce by supplementary.
yes, my lord. Tomorrow I shall produce
tomorrow.
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 And my lord,
And
and
reply in the reply, I am thankful to him that the relevant portion in respect of the
Reply, so I shall hear tomorrow.
my
Okay. And not only that, if court finds that some documents is required, it is within the power to call for that record.
always with the
Really?
statutory is
Even order 27 rule, order 41 rule 27, party has a power, but court has a power. And court power is shall. Party may, court shall. Okay?
I know this.
other
You file, even court is a high court is a court of record. I can call for the entire record.
Kindly direct.
You file supplementary,
Yes,
come tomorrow, and the rest part of the reply tomorrow, just 5 minutes and
my
complete.
lord, before my lord, I have not my lord, finished because of my lord, my learned friend has
How much time you will never?
my learned friend says my lord, more allegation I have to.
Forget about that. Court is to control. Otherwise, one matter, one day.
because
entire day.
my learned friend, my lord, raised.
Kindly record harding part.
Yeah, tomorrow anything can be changed. I don't know.
Let it. Let there be an order, online order.
আচ্ছা ও আচ্ছা আপনি লিখুন
Kindly keep it at 2 p.m. Lordship. I will be here. Lordship.
2 p.m. up to 30th April you will not get আচ্ছা 2020
Lordship. 20.
okay day after tomorrow করে দিন।
My lord will be sitting after recess.
হ্যাঁ why not
I'm coming.
you give me a leave
No. I want to do this. I'm coming with my other side if possible.
PM fixed matter, item number 21.
21 Lordship, I'm for the school Lordship.
Okay, not today. Again, it should be fixed.
Lordship, kindly pass and short order, pass short order. Otherwise, they will not appear. Lordship, already fixed matter.
Wait, fixed.
Lordship, kindly fix the 2 p.m. tomorrow also. That is the Lordship. Only not today will not survive.
Okay, tomorrow will.
No, Lordship, that matter is fixed 2 p.m. On 9th April. Order sheet. Lordship, kindly see the order sheet, Lordship. Kindly.
I know.
Lordship, kindly pass an order tomorrow. I will inform them, Lordship. Tomorrow that is so fixed. I will inform them. Lordship, kindly. Otherwise, the matter will not be hard, Lordship. Again.
Tomorrow they may be in difficulty. One day it would be appear. It will appear.
Lordship, since the matter is fixed at 2 p.m., Lordship, kindly fix the matter 2 p.m. I have no other prayer, Lordship. Tomorrow at 2 p.m.
No. Tomorrow many other matter at 2 p.m. Fixed at 2 p.m. Okay. Many other matter.
Lordship, another day, Lordship, 2 p.m. Since
আগের দিকে দিয়ে দেবেন ফেয়ারলি একটা টপ করে দেবেন ঠিক আছে
kindly, Lordship,
okay it will appear no okay it will appear
Lordship, this matter is pending since long. That is why I am praying for Lordship, kindly fix already Lordship was pleased to fix the matter. Otherwise, the other side is not appearing, and another side, the state is not appearing. That will be difficult for your hearing of.
It will appear fairly at the top on any day. ঠিক আছে thereafter again it would be fixed. Don't worry.
Oh, that will be fixed in top.
Okay, it would be fixed. আপনি একদিন দিয়ে দেবেন এটা ফেয়ারলি একটা টপে একদিন দিয়ে দেবেন
আর লসে
কালকে দেবেন ফেয়ারলি একটা টপে কালকে ঠিক আছে এবার দেন কটা আছে
রিপোর্ট ফাইল রিপোর্ট
You are for the petitioner?
No, he is for the state. The state will file report. Kindly see that.
ছিল না একটা ইনস্ট্রাকশন নেওয়ার ছিল that commission that has not been formed one commission
না রিপোর্ট তুমি অর্ডারটা লাস্ট অর্ডার দেখো তোমাকে ডাইরেকশন দেওয়া আছে স্টেট কে লাস্ট অর্ডারটা লর্ডশিপ কাইন্ডলি সি লাস্ট অর্ডার লর্ডশিপ দেয়ার ইজ এন ডাইরেকশন অফ দ্য স্টেট
ওকে ঠিক আছে আজকে তো হবে না 2 pm ওকে আপনি একদিন দিয়ে দেবেন
লর্ডশিপ কাইন্ডলি ফার্স্ট short order lordship the state is present lordship
point that matter
there is a
absence of the petitioner okay why are you insisting only today order is required
no not
tomorrow okay. next
Number 22
পুরুষই মাথার উপরে ঘাড়ে yes আর 2 pm আছে এগুলো মেনশন করছেন না কেন 2 pm গুলো না সেটা বলো লিখে দিই ঠিক আছে
item number 2 PM fixed matter, another matters, item number 60.
স্যার আমি পিটিশনার আমি এই কেসে হিয়ারিং এ পার্টিসিপেট করছি না আমি এই কোর্টকে অনুরোধ করছি এই কেসটা অরিজিনাল যে কোর্ট জাস্টিস অরিন্দম মুখার্জি সেখানে পাঠিয়ে দেওয়ার অনুরোধ করছি কারণ এখানে আমি বিচার পাবো বলে আশা করছি না স্যার আমি রিটেনে একটা জানিয়ে দিচ্ছি স্যার আমি কোর্টের পারমিশন নিয়ে আমি কোর্টটা লিভ করছি স্যার এখানে বিচার পাবো না বলে আমি অনুরোধ করছি কেসটা অরিজিনাল কোর্টে পাঠিয়ে দেওয়া জাস্টিস অরিন্দম মুখার্জি
মামলা
lordship
আচ্ছা the matter stand deletes from my list due to my personal reason ঠিক আছে okay Next,
Item number 23.
23.
Chattopadhyay appearing, I informed him.
No, not today. What can be done? Not
Can it
today.
be, upgrade?
No, not today. Let it remain. Next.
24,
Uh,
25,
not today.
26, 27,
Yes. Tomorrow, do it tomorrow.
28, 29, 30, 31,
My lord, 31, I am appearing on behalf of the private respondents. I am appearing on behalf of the private respondent.
Tomorrow?
32, 33, 34, 35, 36, 37,
37, my lord, I beg to appear for the on behalf of the school. There is a direction for filing an affidavit in opposition.
File tomorrow?
Although, my lord, this matter has been, this 2022 matters, after a long time it has been mentioned without any notice, my lord. Suddenly, my clerk.
Okay, now you have come to the knowledge that,
followed that.
yes.
38, 39, 40, 41, 42.
My lord, item number 41, Mr. Debashish Shah is appearing for the petitioner in this matter. He is on his legs in another court. My lord, kindly fix this matter on next Wednesday, if possible, my lord.
No, so I am making not this week. Not this week. Item number?
41.
41, not this week. Yeah.
43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59,
এই ওকে ডাকুন, ও কোথায় গেল?
61,
Lordship 59, we are appearing on behalf of respondent number 2, 6, and 7, Lordship.
Not today, only action for the day.
Lordship.
Yes.
62, 63,
এই ওকে ডাকুন, ও কোথায় গেল? এখানে আজকে এই পর্যন্তই ডাকিনি কি? আর কম্বাইন লিস্ট ডাকবেন। হ্যাঁ, আমি আমার লিস্টটা কমপ্লিট করি। হ্যাঁ, লিস্টটা কমপ্লিট করার ওই ইয়েকে ডাকুন, যে বোন রেডি থাকে। Yes.
64, 65, 66, 67, 68, 69, 70, 71, 72, 73, 74, 75, 76, 77, 78, 79, 80, 81, 82, 83, 84, 85, 86, 87.
87. Appearing on the behalf of the petitioner, paying,
87?
paying for not today, my lord.
Not this week.
No, not today.
Not today, only not.
Day after tomorrow. 59, petitioner has not appeared. Don't take it up tomorrow, take it up day after tomorrow. I'm not asking for any other order in his absence.
No, I am not upgrading. You mentioned for upgradation, if mentioned, it would be upgraded.
No, 59, I am for the respondent.
Ah.
But tomorrow I have some difficulty if it may be taken up day after tomorrow. That's the only thing.
Okay. So
petitioner
not
is-
this week, that would be,
Not this week, then again 16, 17. Petitioner is not here, my lord. I should not take advantage. Only tomorrow I have some difficulty.
okay, এটা আপনি ইয়ে করবেন।
Just mark it, my lord, may mark it in the list for day after tomorrow only. Because
That should be
59.
specially fixed whether he will be available or not.
my lord may not. As your lordship, please, I
Uh,
have some difficulty.
Giving a date means it has been specially fixed.
That is true.
My lord, I have the similar prayer, my lord, with regard to item number 40. 40, my lord, I appeal for the state respondent. Lordship, I have some difficulty for tomorrow, my lord.
No, junior, you ask your junior to pray for adjournment at the when the time.
Tomorrow, my lord.
Your
Today
junior
petition-
suddenly come, will suddenly come. Always.
Tomorrow, yeah,
Okay,
today
আমি
petitioner was not there, my lord.
ইয়েটা দাগ দিয়ে রেখে দিন তো 59, 40 আর 59. ওকে, আপনি মনে করিয়ে দেবেন। হ্যাঁ, 11 তারিখে কালকে যদি বাই চান্স ইয়ে হয়ে যায় আপনি মনে করিয়ে দেবেন। ঠিক আছে?
My junior will also be here to Milord.
Okay, okay.
কালকে একটু বললেই জসে পরশু রেখে দেবে।
Supplementary list, all matter has been called.
তারপরে অবেলায়
All include.
আবার এই অবেলায় বুঝে বোধ পার্টি
Okay. So adjourn for the day. Don't worry, adjourn for the day tomorrow.